Well, I just demonstrate a few documents. Well, will kindly come to page 19 straight.
This is an FIR.
Yes, FIR. Well, this is 27/5/2019. This is the FIR, Milord, laws against us, the applicant, Milord, I'll not take. And thereafter, this 0 PS case number 20/19, Milord, was registered under the following sections. Milord, important point to be noted in this FIR is that have Milord, kindly come to line 4, Milord. 5, 6, Milord, they came with weapons like thou and rampantly destroyed the plantations of kiwi apple and tea and caused massive damages to our properties. They have also set fire on labor camp mean for dwelling of so and so. Here, my lord, the important line is myself and other witnesses have seen, my lord, just mark it, my lord, for a moment. Then, my lord, the first information report that in the form the police has given that we may skip, my lord. My lord, kindly come to page 23. The statement recorded under 161 before the IO by the complainant. I am to state that today, that is on so and so at around 1900 hours, while I was working in my house, New Pania, well, she was at house, which is 1 kilometer away from the garden lot. I saw huge flames and smokes in my kiwi orchard. Since there was no one present in the house, I walked alone up to my orchard. When I reached the orchard, saw huge crowd consisting of around 30 people. Here, she has not identified the person, Milord. The crowd had already destroyed all my kiwi plantation apple trees. They had also burned down the entry gate, and the labor came. Among the people present in the crowd, I recognize one so and so, so and so, so and so, Milord. Here, Milord, they recognizes me, recognizes us, Milord. Now, Milord, this aspect I'll skip. My lord, kindly come to page 31. This is a final form report, my lord. My lord will only see this page 37. That's
37.
37. 37. There's a final form report, my lord. That's charge sheet number 7, dated 10/7/2019, my lord. That is at page 31. Then kindly come to page 37, my lord. Paragraph 2, my lord. The complainant has identified 5 accused. The complainant has identified 5 accused named in the FIR who were present at the crime scene also, and 2 witnesses, namely Mohammed Siman, 55 years old, so and so, and Vijay Subramlat. So they have identified here also. Now, this has been demolished in her prosecution witness. That's okay. That's okay. This arrest memo form, my lord, I'll not see. My lord will see in the final form charge sheet, no seizure list is there. Suppose if a kiwi garden is damaged, my lord, then certainly if there is an eyewitness and then the police have come, then there should have been a seizures of the weapon used for destroying the garden, my lord. So my lord will kindly come to page 50 annexure 3, Lord. My lord, this particular case is under trial now at the stage of deposition of prosecution witness, and the complainant and the examination in chief in chief, my lord, she has stated, my lord, kindly see. This important, my lord, in this case, because I am praying for the interim order, my lord. Well, so and so first we can skip a lot under oath, my lord. This is important, these two paragraphs. I have already given my statement on 15/7/2023. The photographs shown to me in the court today are the photographs of my destroyed tea garden and TV garden. The photograph also contained the burnt labor house of my garden. I have already named about the accused persons in my earlier statement as to who destroyed my garden. The photographs were taken by my children. These are my children, not my the complaint. Exhibit so and so. Now here, this is very important. In the cross, what she says, in the evening, after the police came, some of the children went to my garden, and I, being sick, remained back at home. I had gone to the garden in the daytime. At the time when the photo was clicked, I was not present in the garden. I am not sure as to who clicked the photo. I cannot name specifically anyone from accused person as to who destroyed my garden and burned down my house, as because before my arrival at the garden, the accused persons are already destroyed. Now, my lord, it is a sterling documents, because this is a deposition by the complainant, says, I have not identified. There's contradictions in the statement, my lord. So therefore, on the basis of this, this alleged accused in the case cannot be prosecuted further. Only, my lord, 2 PWs are left for examination, and it is fixed on 26. Now, this was for this purpose, my lord. Now, my lord, kindly come to page 52. This money suit, my lord, 28/2022. As my lord has seen, the FIR was filed on 27/5/2019, my lord. And after 2 years, this 49 crore, my lord, 50 lakhs with pendency light and future interest accruing thereafter from the dependent, my lord. Now, once my lord has seen in her cross at page 50, she says that I have not identified that. On the basis of that, she cannot claim, my lord. No suit can be maintained in that manner, my lord. So, my lord, kindly come one more. I'll demonstrate it. My lord, in paragraph 6 of the money suit at page 58, my lord. The statement is clinching statement, my lord, that the plaintiff begs to state that when the matter concerning cancellation of LPC was sub judice before the Honorable High Court, Itanagar bench in WPC number, the Deputy Commissioner 0, despite of knowing the pending of said writ petition, has in connivance with the defendant herein and respondent of the aforesaid writ petition has issued an order dated so and so 16/5/2019, thereby illegal cancelling the LPC of the plaintiff without giving her an opportunity. Now, my lord, to establish the title, one must have a valid legal document to claim the ownership. So, in view of this, LPC is also gone, my lord. And one more page, my lord, at paragraph 8, page 59. I am coming to that. That on 27/5, my lord, to 2019, plaintiff was out of station, and therefore, so and so the complainant, my lord. The second, so this, I keep reading this. I don't want to read this word second wife or all this thing. Had lodged an FIR before the OCPS 0, and accordingly a case white so and so was registered, my lord. This is to this extent, my lord, just to show that, and then charge sheet has been filed on 7/10. Now, my lord, the deficiency that I find. Okay. Now this title suit, my lord, 28/2022 is again directed to be listed on 7/8/2023. 7/8/2023. The order copy is there, my lord, page 73. My lord may just indicate that. Now, these money suit, my lord, the basis of institution of this money suit is on the basis of the charge sheet filed by the IO of the case, my lord. And the deputy commissioner constituted one committee. The committee has not gone to the field, conducted the actual verification, my lord. So incident that has occurred in 2019 and 22, you are doing this. 29 March 2022, my lord. I'll demonstrate that, my lord. And I'll place one small authority so that no, around 500. That's okay. That's okay. My lord will kindly come to page 74 and 75 first. Now, my lord, somebody must have advised the complainant. You should also simultaneously proceed with the money suit. And unfortunately, on the basis of the evidence that has been furnished by the IO of the case, I'll rely on that judgment. Kindly see. So she has written this only for the reference, 25/02/2022. Now, thereafter, it was marked to the additional deputy commissioner Yachuli, under whose administrative jurisdiction it falls. Will kindly come to page 76 at Annexure 6 series. 3 paragraph is important. This and assessment of damage of agri hall tree garden of Srimati so and so, my lord. And application duly addressed to DC Lower Subansiri received from Srimati so and so on the Lower Subansiri district scene flag A for assessment of damage to her agri horti garden at Philsit area basing on the record available in the charge sheet, my lord. My lord will mark this charge sheet. However, on detailed study of the application and records attached therewith, the following facts and figures are found. The finding of the ADC, my lord. As per para 2 of the application, the matter appears to be arising out of a land dispute in between 2 opposing parties, viz. Likha and Neelam party, since a FIR been lodged by the applicant in a police station, and the police had investigated the case and charge sheet filed in a honorable court of law. The matter appears to be sub judice. The first finding. The second finding, as per para 4 of the application, on earlier occasion also, the district administration had attempted to assess the damage of the assets of the applicant by Neelam party, but the assessment team failed to do so due to obstruction from so and so. 3, as stated in paragraph 2 of the page 2 of the application, the applicant quoted the investigating officer's verification report of destruction of around, my lord will mark this, around this, my lord will read with page 37. Around what, not concrete, around 500 kV so and so numbers of apples along with destruction to other infrastructures. The investigating officer had also quoted the same figures, my lord will mark this, had quoted the same figures, my lord, in the final report of the matter, scene flag B, which appears to be not meticulously counted. Therefore, it appears that the figures quoted by the investigation officers are a lump sum figure, and hence, if challenged in a court of law, it will hold no ground. Now, the my lord, an administrative officer is very conscious of the court proceedings, that if on the basis of the lump sum, you cannot sustain before a court of law, and para formula. And further, and another order attempt to assess the damage of the assets of the applicant with the adequate police force was carried out on 30th August 2019, but the assessment team could not carry out so and so. Therefore, my lord, in view of above facts, it is proposed that since the matter appears to be sub judice and the figures of damages appears to be not factual, the assessment on tabletop basing upon the final report of the investigation officer may not be carried out. Here, the additional deputy commissioner consciously says, no, on the basis of final form report of the IO should not carry out. However, if the deputy EDC Lower Subansiri wishes to carry out the top table exercise of the assessment of damage to garden of the applicant, it is proposed that a proper board of officer comprising from all the departments, so and so, along with the investigation officer of the case be constituted. The investigation officer case may also be asked to certify that she had actually conducted a verification and the figures quoted is true to her knowledge. Now, my lord, kindly see left, there is a handwritten mark. It was marked to the deputy commissioner, and the deputy commissioner has directly marked to the district horticulture officer. Then, pursuant to this, what had happened, my lord, will kindly come. My lord, kindly come to page 82 straight. Now, thereafter, my lord, this is a communication on 25, my lord. 25.3, my lord. Now, this is an order coming out. Why DC 0 approval directions so and so DHO 0 and so horticultural development officer actually are hereby directed and engaged to prepare loss assessment of agri horti garden of so and so village so and so of Lower Subansiri district, basing on, my lord will mark this. Final report of the investigating officer Y0 case number so and so furnish the report, my lord. Now, kindly see, my lord, Annexure 8 series page 83, my lord. Now, my lord, see, at least one has to go to the field and carry out the exact assessment. And assessment also cannot be done in the present form after the lapse of 2 years, my lord. Kindly see how this was prepared sitting in an armchair table, my lord. To the deputy commissioner, submission of loss assessment report as per charge sheet number so and so, charge sheet, my lord. Charge sheet number. So now, with reference to the subject cited above, I am submitting here with the loss assessment report as per the investigating officer's report in respect of damages to the horticulture garden situated at Pili Sit area, New Pania. Hence, enclosed, please find here with the loss assessment report prepared as directed by you. Now, my lord, this is next day, 28th, the DC gives the order constituting a committee, and the committee, without affording opportunity to the other side, has concluded this, prepared this report and submitted, my lord. Now, this cannot be. Now, my lord, this is on the basis of the finding by the IO. So now, my lord, this Annexure 9 is relevant because it is fixed on the criminal case, my lord, that session jet, my lord, case number, my lord, for the reference. 07-2021. It is to be listed again on 26, my lord, as I refer to the name of Vijay, Subro, and Mohammed Siman are absent on 3 occasions, my lord. Now, my lord, the law is very clear in this case. It is no more Santigra that both civil and criminal proceeding can proceed simultaneously, my lord. But the condition is that if the criminal case is instituted prior to the civil suit instituted at later point of time, if the facts are similar and born out of the same facts, then, my lord, that we immediately recall that section 11 of the CPC res judicata. So, my lord, when we talk about the res judicata, then estoppel will come, lord. So here, I refer to this. My lord is aware that Said Aksari Ali judgment. simultaneous civil and criminal proceeding in a given matter. Well, kindly come to paragraph 21 straight. On the proposition, paragraph 21, I am reading on a proposition that both civil and criminal proceeding may proceed simultaneously, my lord.
Yes.
Indisputably, in a given case, a civil proceeding as also a criminal proceeding may proceed simultaneously. Cognizance in a criminal proceeding can be taken by criminal court upon arriving at the satisfaction that there exists a prima facie case. The question as to whether in the facts and circumstances of the case, one or other proceedings would be stayed would depend on several factors, including nature and stage of the case. Madam, let us see nature of the stage, nature and stage. Here, only next date is fixed 7th August, only for the appearance and then filing the WS. Now, in the criminal case, it is in the deposition stage of the prosecution witness as provided under section 101 of the Evidence Act. Only 2 prosecution witnesses are left. So the stage, the criminal case stage has gone beyond. Now 22, it is, however, now well settled that ordinarily a criminal proceeding will have the primacy over the civil proceeding. Precedence to a criminal proceeding is given having regard to the fact that disposal of a civil proceeding ordinarily takes a long time, and in the interest of justice, the former should be disposed of as expeditiously as possible. The law in this behalf has been laid down in the larger number of decisions. We may notice a few of them. So one is that Mr. Sarif's case, that is, my lord is aware. So that is still, that paragraph 24, this paragraph 23 is also important because there is a possibility of giving a conflicting judgment. Because if, say for example, the corollary would be, in view of her deposition and in the cross, that I have not seen the accused person. If these applicants are acquitted, then this civil suit will not lie. Meaning thereby it would be an abuse of process as provided under section 151 of the CPC and so forth, my lord, catena of judgments. So my lord, I may kindly be granted liberty to read these 2 paragraphs at least to convince my lord. In MS Sarif versus the State of Madras, a constitution bench of this court was seized of a question as to whether a civil suit or a criminal case should be stayed in the even both are pending. It was both now in our case, it is proceeding simultaneously. It was opined that criminal matters should be given precedence. In regard to the possibility of conflicting in decisions, it was held that law envisages such an eventuality when it expressly refrains from making the decision of one court binding on the other or even relevant except for certain limited purpose, such as sentence or damages. It was held that only relevant consideration was likelihood of embarrassment. Now, what would be the embarrassment, my lord? This money suit has been instituted after a much thought. Because the moment they came to know that in the cross, she has already contradicted and admitted that I have not seen them on the spot. So, meaning thereby, my lord, section 58 of the Indian Evidence Act is very clear. Fact admitted need not be examined and it is accepted fact. So therefore, para 24 is important in my case, my lord. If primacy is to be given to a criminal proceedings, indisputably, the civil suit must be determined on its own merit. Now here, I'm pausing, my lord. Evidence of the criminal case has been used vividly in this document, only on the basis of the charge sheet. So therefore, keeping in view the evidence brought before it and not in terms of the evidence brought in the criminal proceedings, my lord. That is what the proposition I am submitting, Lord. Because purely whatever evidence has been collected by the IO, and on the finding of the IO, this money should has been instituted, my lord. So then these are quoted, my lord. I'll not burden my lord with this authorities. My lord, there is one more small authorities. There's one more case. By our High Court only, Agartala, at that point of time, my lord, by his lordship, BP Kataki. Yes, that Sharif case has been relied in para 13, well, just only for that proposition. I just, in fact, here the facts are a bit different. Akbar Ali Hadi Malab para 13. This proposition of law has been recognized by this our honorable High Court. So therefore, beloved, I pray for staying of the further proceedings of the civil suit today. Beloved. And if the other party, Milord, I'll take steps and all. If they are agree by this, let them come and file interlocutory application to vacate it. Milord. Otherwise, it is a clear-cut abuse of process of the court, Milord. And the reason why, Milord, I have referred to the deposition of the PW1 is important was a complainant also, Milord. Yeah. Grateful.
Yes, ma'am. Thank you for the information.
Yeah. ये already post करके रखा था क्या? Post करके रखा था।
Lordship, may I please?
Yes.
Lordship, this is joint application filed under section 482 of CRPC.
It was a
By
case under which section?
LI section charged under 417 of IPC. Compoundable in nature. Charge was framed under section 417 of IPC. And regarding that, 320 of CRPC, joint application was filed before the Lanet CGM UPR, praying for compounding, but same was not allowed.
Right. It is a compoundable offense. It is a compoundable
Yeah,
offense.
compoundable in nature, 417 compoundable in nature.
417, you're in petition, which petition number? You are on 15, number 15,
Yes, item 15.
item number 15,
Yes,
417.
yes.
Your case is 417.
IPC. Charge section is 417. IPC.
No. These are section 279, 3048, 338.
That is earlier charge sheeted and same that section was dropped. And
All the
charge was,
sections were dropped.
yes, charge was frame only 417 of IPC. Kindly,
How 417 is related with 279, 3048?
that was not attracted
No.
during the framing of
How
charge.
Can be related, just two different sets of charge.
Hmm.
It is which case one? You are on 15.
Item 15.
No, your lordship,
No, I think.
they were charge sheeted under 419, 420, 468 and 34. I guess.
419.
I think it has wrongly been numbered.
130.
The name is Bake John alias.
Earlier there was an accident case.
Yes.
He has mentioned all these things now, that's why.
Yes.
Then subsequently what happened?
The charge was framed under section 419 of IPC.
Page number 16.
Page
your
number
lordship.
16. 417, charge was framed under section 417 of
So
IPC.
why you have brought all other things that the one case was registered under section 338, is that why you have brought this thing?
That was not relevant. That's why the learned CGM UPA dropped that section. Only charge under section 417.
I'm not following. The case was registered under section 379,
Yes.
3048, 338, then
Case was registered under earlier 419, 420, 468, 34 IPC.
these are not here.
After heard, the learned
you get that under section 417 IPC, which is the component manager. Page number 16, order dated 28/4.
22. May I read the order? Case is fixed today for CC. Hard parties on charge. There is the police report along with the document enclosed with it. The accused in present case were charged sheeted for offense punishable under section 419, 420, 468, 34 IPC. However, on perusal of the case record, there is no ingredient of the said offense, but there is sufficient evidence to proceed against accused for offense under section 417 of IPC. Accordingly, the particulars of the offense alleged against the accused were stated, to which they pleaded not guilty and claimed trial. After framing of charge under section 417 of IPC, the accused persons along with the complainant filed a joint application before the trial court under section 320 of CRPC, praying for allowing them to compound the case, but same was not accepted by the learned court below.
If I may clarify the entire facts of the case, your lordship. This is a case,
Now I have come to this.
yes,
Earlier, there was a case under section 270 and so and so.
Yes, yes.
Regarding the release of vehicle, some. sort
Yes.
of thing.
One
Yes.
FIR, this case is arising
the
out of
different cases
FIR.
were there.
Yes.
One was the main incident, subsequently due to person,
While at the time
impersonation,
of release of the vehicle, there was some
Yes, yes.
misperception.
that case was raised.
Lordship, this case is arising out of one FIR, which was filed by the council.
So your petition is, how we have drafted your petition?
Page number 14, annexure 2 is a FIR lodged by the petition number 3.
Your drafting the petition is very confusing. It's not at all anything in this case. It is not.
Even otherwise, if I may, your lordship, in this petition, Your Lordship is well aware that 482 confines only to cases which are non-compoundable.
Yes, not compound.
This case, as per the submission, Your Lordship, 417 is compoundable. Your Lordship. Therefore, they have filed an application. Your Lordship will find at page number 18, Your Lordship. They filed a petition before the learned court for compounding of the offense on the parties settling the matter. Your Lordship. Now, subsequently, Your Lordship will see that the order at page number 29, Your Lordship. Your Lordship will see their application was rejected, Your Lordship. With an observation that this was not only between this party and other parties were also cheated, Your Lordship, and they were not party in the compromise, Your Lordship. Now, Your Lordship, they have come under 482 and 401 revision. Your Lordship. However, Your Lordship, they have not challenged the order of this trial court. That ought to have been challenged, Your Lordship. They cannot come to this honorable court under 482 for compounding of compoundable offense. They ought to challenge this application that the trial court has wrongly not compounded, or in any other reason that they have not, the trial court has not compounded, and that this order ought to be challenged, Your Lordship. However, if Your Lordship will see their entire cause title is only with regard to the GR case and the FIR, Your Lordship, and also the prayer is for the quashing of the entire proceeding
Yes.
in terms of settlement. So this is
That
not
means,
maintainable.
apart from these two petitioners, there are other persons are also involved.
Yes, Your Lordship. And therefore, this on the trial court has they rejected the application and did not compound the offense, Your Lordship. Now, under 482, Your Lordship is well aware that this is not maintainable at all, Your Lordship.
Lordship, in
They
this
ought,
case,
they ought to come under 482. They ought to have challenged the order of the honorable court under revision, Your Lordship. 401 is already there, Your Lordship, but their cause title as well as the prayer, they have nowhere challenged the impugned order that ought to have been challenged, and therefore not maintainable.
I may be allowed to withdraw.
To pass any
Yes.
other order,
I-
you just withdraw this one.
Yes,
And file a fresh. one.
I may be allowed to.
Yes.
Present
Because your
file.
entire petition is defective as
Sure.
soon as he submitted, this is not at all maintainable. Because it is a compoundable offense. Rather, I guess you can challenge the order of the court. If it is not, and there may be cases where the compounding of a case for a particular person or particular accused can also be done. That is option is also there. So you can very well
Yes.
could have apprised the court regarding that provision also.
Yes.
Had Mr.
Titoro.
Titolo, the learned counsel for the petition, also had MSTJD, the learned additional PP appearing on behalf of the state respondent. This is an application under section 482/401 of the CRPC for quashing and setting aside the proceeding. Entire proceeding of GR case number 401/2015 arising out of Naharlogun PS case number 107/2015 under section 417 IPC. However, it is submitted to the London Council for the petitioner that there are some technical error in the filing of the criminal petition, and hence he wants to withdraw this prayer allows the petition is accordingly disposed of withdraw.
Obliged.
Yeah, Lordship, this is also a joint application under section 482 for passing of an FIR dated 15/8/2019. Lordship, what has happened, this is a joint, petitioner number 1 is the victim and petitioner number 2 is the alleged accused in the.
One
Lordship,
is the accused,
yes, Lordship.
two is the victim.
No, one is the victim, complainant, and 2 is the accused, alleged accused. Lordship, what has happened in this matter is that in the year 2019, and Lordship, here the petitioner number 1, that is the victim lady, is the best friend of petitioner number 2, younger sister. What has happened in this matter is the in the brief, in the year 2019, the petitioner number was shifting her room, has shifted her room nearby the college. So she has called the petitioner number 2 younger sister to help out her for shifting her room and cleaning. So accordingly, after the household activities done, so they went to the petitioner number 2 house, since they're from the same place, from the same area. So they, before this also, they used to come and go. They were like a family only. And then they reached the house of petitioner number 2 around 9:30. So after having dinner and all, like around 11:30, the petitioner number 1, who is the victim, has insisted that she be dropped to her room rent. So accordingly, petitioner number 2, like she dropped her to took her in her vehicle, and on the way, Lordship, I have made a special appointment also here that he has suggested let us go for some more joyride. So in there, you're not in the taking her in a vehicle. Seems like there he made some proposal. Said, I want to marry you. This and all that. So and accordingly, while after going for some while, the petitioner number 2, who is the accused, got down from his vehicle for nature call for urine. Then taking advantage of this, the petitioner number 1 got down from vehicle and ran away from the. And he didn't, since it was dark in the late night, like around 12 in the morning, she hid there, and next day she went back to her room. Then she attended her classes. On the incident happened on intervening night of 12 and 13, and the complaint was made on 15 after 3 days, Lordship. So I have made an appointment also that this complaint was made on instant of the parents, on the elder brother of the petitioner number 1, since at that point of time they were having some political feud between them. So to take that, this complaint was made. Incident happened on intervening night of 12, and the complaint was made on 15, Lordship, after a couple of 3 days. Since Lordship now they are staying as a good neighbor, so they have all that the dispute between the family have solved. So they have made a deed of settlement between them also, which I have annexed, Lordship, in my annexure, page 41, Lordship. This
1-4.
yes,
Page 1-4 or
41, yes, Lordship, 41.
4-1.
Yes. Lordship, this is a deed of amicable settlement agreement that is between so and so, that is the petitioner number 1, and Mr. So and so is the petitioner number 2. That is the marriage, they have made all the agreement also, like deed of settlement. So she is also no longer willing to pursue the case any longer. Since the Lordship, the instant case which has been registered at Itanagar WPS case number 49 of 2019. The trial has started, so my prayer for this honorable body, the proceeding before the session court, which has been registered as section 49 of case number 45 of 2019, maybe or 22, maybe state, and LCRB called also. That is my prayer.
Yes, Your Lordship. LCR may be called for you.
That's really good.
Yes. Scan code.
Mr. Bijam.
Yes, Lordship.
The London Council for the Infection. So her investigating Invalidation duty at the considering this submission made by the London Council for the petition, the matter is that let the SJB scan of the SJB copy. Distribute to the needful. Let the matter be listed after. It will take 2 weeks. Within 2 weeks, it will reach or 3 weeks.
2 weeks, Your Lordship, it is upstairs.
It's after.
Session.
On the receipt of the SR is proceed. Yes.
Proceedings till then also,
Proceeding.
since the trial has come in, Lordship, till then
Proceeding.
of this, which has been registered as session case number 49 of 2022.
Case number 49.
Yes, Lordship. In my prayer section, page 10, Lord Shiva, page 11.
Can you please come back?
Page 11, Lord Shiva, in
Page?
interim,
Page?
11, Lord Shiva, in interim, I've got some.
Further considering the submission with the counsel for the petition, and also considering the fact that there is a performance between the parties. Let the further proceeding of session case number 49, 2022 in ITA WPS. This is ITA WPS
It's Itanagar.
in
Women-
connection with.
Yes, Lord.
In connection with ITA WPS case number 45, 2019. It is state. Until further.
Your lordship, if your lordship reflects the session case number, your lordship. Session case number 49 of 2022.
Yes, yes, I have it. 41.
Deeply.
Deeply.
Yes, item number 2. You have for the petitioners?
My lord. Lord, this my lord, petition my lord can be taken up for disposal, my lord, as I am only making submission of one legal aspect only, my lord.
Then the other side is.
Other side was present.
The Panging is there, no?
Deepang, my lord, he is a junior is there, my lord.
You are in the same chamber, the Panging?
We have still chamber, Lord Shiva. Is it possible for me?
He is here.
So you are appearing or he is coming? Mr. Panging is also coming?
No, Mala, I'm appearing.
You are going to prepare.
Issue, my lord, here, my lord, I am impugning, my lord, order dated 12/4/2022, my lord. Only on one legal infirmity, my lord. This order, my lord, is beset by legal infirmity, my lord, 12/4/2022, my lord. This is before coming to this order, my lord, this order is passed by CO, my lord, circle officer for the deputy commissioner, my lord. While
Circle officer?
for the deputy commissioner, my lord,
For the
CEO, my lord. Now, my lord, note that under 1945 regulation, my lord, the authority, my lord, any authority, my lord, like Gambura, my lord, the ADC or DC, my lord, all exercising judicial jurisdiction, my lord, authority, my lord. Now, the issue I am raising, my lord, issue only is, my lord, whether there is any concept, my lord, of delegation of judicial power, my lord. That's the only
There is
issue.
any concept of
Delegation of
delegation.
judicial power, my lord. That's the only issue involved in this case, my lord. And my answer to that, my lord, is humbly, my lord, there cannot be, my lord. There is any non-law, my lord, whereby, my lord, a judicial power, my lord, power can be sub-delegate to any authority, my lord. So only on that issue, my lord, I am referring, my lord, page number 33, my lord, to indicate that, my lord, how this order is beset by legal infirmity, my lord. 33, this is the impugn order, my
Page
lord.
32.
33, my lord, 33. My lord, 33, my lord.
Starts from 33.
Yes, my lord. Annexation number 1, my lord. This is the only, this is the impugn order, my lord. I'm from here also, my lord. I'm not reading the whole part, my lord. Yes, I already indicate, my lord. I'm only indicate the legal infirmity in this order, my lord. I'm reading from my lord, para 1, my lord. This is the peg. The land dispute case was reported to the deputy commissioner through a complaint dated 20 May 2000 submitted by Sri such and such, wherein she alleged that Sri such and his son such and such had illegally occupied his private land near Gogar village. The deputy commissioner forwarded the case to Sri such and head Gambura Malani village dated such and such 20 May for settlement of dispute. such and such head Gambura had convey Kebang dated 2006, but the respondent did not attend the Kebang. Hence, the dispute was not settled here. The deputy commissioner bid later dated such and such had again forwarded the case to say such and such, such and such. The village authority of Gogar village under the chairmanship of such and such Gambura had settled the dispute on 25/2020 and demarcated the land boundary of see such and such and such and such. Also, the Kebang had demarcated the boundary of Simultaneous such and such, whose land also fall within the disputed plot. See, such and such has appeal against, this is the respondent matter. See, had appeal against the decision of the impugned Kebang dated, this is the impugned Kebang matter, 27/5/2020, due to the deputy commissioner bid appeal application dated 26/6/2022. The deputy commissioner, my lord, kindly note here, the deputy commissioner had enrolled the case to undersign for amicable settlement. However, due to the COVID-19 pandemic, the case could not be progressed further. Hearing was conducted. My lord, kindly note, this is, my lord, the Kebang, my lord. Other aspect, my lord, is not necessary. The Kebang order, my lord, 25/5/2022, my lord, was appealed by the respondent, my lord, before the deputy commissioner, my lord, under 1945 regulation, my lord. The deputy commissioner has absolute jurisdiction, my lord, at that point of time. Now it has been to endorse a civil court, my lord. Now the appellate, my lord, authority exercised by the deputy commissioner under 19/5 regulation is a judicial authority, my lord. Now whether that judicial authority, my lord, can be, my lord, to serve delegate to the CEO, my lord. Now, after this appeal, my lord, was endorsed to CEO, my lord. Accordingly, my lord, CEO, my lord, has passed this order, my lord. So my humble submission, my lord, this order, my lord, is ordered by quorum non-judice, my lord, ordered without any jurisdiction, my lord. So that extent only, my lord, this can be interfered, my lord. And to fear the purely, my lord, other side also has no objection to it. I think it by reply, my lord. Only to the legal issue, my lord, I rely on this, my lord, this aspect. Para 17 would be relevant, my lord, 17, my lord. This is reported in 2017 for SSC 498.
You are relying on para 17.
17. I am reading, my lord. It is evincible from the impugned order that the learned judge has laid both the aspect that is determined of the nature and character of the document and impugned of the same to the registrar. Therefore, the sentinel question that arises for consideration is whether the single judge, for the purpose of determining the character of instrument, would have delegated the authority to the registrar. Now, it will read, my lord, a judicial functioning has to be done in judicial manner. The duty of determining an instrument or to explicate to determine who, when there is a contest, a particular document to be especially necessary, adjudication has to be done by a judge after hearing the consular party. It is part of judicial function and hence the same cannot be delegated. Now, I am indicating, my lord, ultimately, my lord, appeal was filed by the deputy commissioner, my lord. Under the 1945 regulation, it was the deputy commissioner who ought to have considered his appeal, my lord. There cannot be a concept of sub-delegation of the judicial power, my lord. Now, undisputedly, on the face of record, my lord, this order, 12 April 2022, is passed by circle officer for deputy commissioner, my lord. So my humble submission, my lord, this is ordered by quorum non-judice, my lord. So in that kind of other aspect, my lord will interfere this order with a liberty, my lord, to both the party to file appropriate remedy against the Kebang dated 27/5/2022, my lord. Yes, because, my lord, at this stage, my lord, this cannot be remanded back to the DC also, my lord. Because, my lord, now that authority, my lord, appellate authority has been entrusted to the civil court, my lord, regular civil. So that is my humble submission.
My lord, the issue is here, my lord, whether the CO or DC can pass this order or not, my lord. The issue is only is that, my lord. Otherwise, my lord,
I am filing the appeal before the DC, madam. The DC was the
Against
person,
order of Kebang, you have preferred the appeal
yes, I have
Before
preferred the
DC.
appeal against the order dated 25.
by Kebang.
Yes,
Kebang
ma'am.
decision.
Kebang decision, ma'am.
But the question or issue is that though the appeal was filed before the DC, he delegated or sub-delegated power to CO and CO filed the or passed the order.
Yes, ma'am.
That is the issue.
Yes. This is the only issue.
Otherwise, is there any provision before the civil authority, forum was there? The DC, because the circle officer is also acting under the DC. So was there any other provisions or that what the delegation of power, etc.? Because I'm not aware of all this. And if we agree to that, that there should not be or delegation should not be there. Power cannot be delegated to the other side. CO, then in that case, can dispose the matter to the itself.
Yes.
I think, my lord, if kindly look at their power, my lord, they had conceded that part, my lord. Humbly, they have clearly conceded, but there is no support. Because, my lord, undisputedly under 1945 regulation, there is a three-tier system of judicial. At Kebang, my lord, there are appeal, my lord. Appeal before the deputy commissioner, DC or ADC. Or some in terms of jurisdiction, some pecuniary jurisdiction, ESC is also there, my lord. Now, here is a case, my lord, yes, the appeal has been made under to the deputy commissioner, my lord.
Can you give us the
1945 regulation, I have not got my. That in volume 1, my lord. Volume 1.
which section you are citing? 45.
15.
Civil proceeding, my lord, start from page number 63, my lord. The appellate jurisdiction, my lord. Yeah, 46, page number 66, my lord.
60?
66, double 6, my lord. Forty-six, my lord. Any person agree by decision of village authority may appeal to assistant commissioner, my lord. This is ESC, my lord. Now, in suit not exceeding 500 in value and to deputy commissioner suit exceeding value, exceeding that value, my lord.
And if appeal may lie before the assistant commissioner in suits not exceeding rupees 500
My lord.
and before deputy commissioner, if it exceeds 500.
500. Here, my lord, his appeal, there is no wrong in any wrong in the appeal, my lord, filed by the respondent, my lord, deputy commissioner, my lord. But the issue is, my lord, the dead appeal, my lord, whether can be endorsed to either CEO or anybody, my lord. My humble understanding, my lord, in any circumstances, my lord, judicial power, my lord, cannot be delegated, my lord. Now here, my lord, this is judicial power of the appeal authority that has been endorsed to the CEO, my lord. My humble, my lord, will interpret this impugn order, my lord, with a liberty, my lord, to both the party to avail remedy against the Kebang decision, my lord, Kebang decision dated
27.5.
27/5 2020, my lord. That remedy, my lord, that will not prejudice the respondent or something. He will file appropriate remedy, my lord.
Heard Mr. L. Parmati, learned counsel for the petition, and also heard your good name,
M. Doji, madam. M. Doji.
M. Doji, the learned counsel appearing on behalf of the respondent.
Respondent number 1.
Respondent,
1.
respondent number 1, and
Yes.
rest of the respondent.
My here
Is
is
there any other respondents also?
2, my lord, 2 is the, my lord,
Another
his performer respondent, my lord, in this case, my lord. I think the service of notice complete to his respect. Other, his performer respondent. my
Reply
lord.
not yet filed by the service is completed. He was performer.
Performer only, my lord, performer respondent.
Mr. Alpami, the learned counsel for the petition, and also heard Mr. M. Dochi, the learned counsel appearing on behalf of the respondent number 1. From office note, it reveals that the service is also completed on respondent number 2, who is the performer respondent, but none appeared on behalf of the respondent number 2. It's an application. An application under Article 227 of the Constitution of India, read with Section 115 of CPC for setting aside and washing of the impugned judgment / order dated 12/4/2022, passed by the circle officer on behalf of Deputy Commissioner Likavali, Lower Siang District, Arunachal Pradesh, in a land dispute case between the Domodini versus Sri IDRRI Dini and another, bearing case number LKB JK -46 -09 2018 under section 46 of AF bracket of AG bracket close R 1945. It is submitted by the learned counsel for the petitioner that the order dated 12/4/2022 was passed by circle officer on behalf of the Deputy Commissioner Likavali, Lower Siang District, without having any authority or power. Having any authority or judicial power to decide the matter, which wherein the appeal was filed by the respondent against the Keba decision dated 27/5/2022, which was passed by the customary court of the Gagor Village Authority. So the only issue raised in this revision petition is that whether the circle officer has the power of judicial can act as and can pass the order, can pass the judicial order, or whether there is any whether the judicial power can be delegated or sub-delegated to the circle officer by the Deputy Commissioner, who is authorized to deal with the appeal, which is filed against the order of the Debang decision. Accordingly, it is submitted by the learned counsel for the petitioner that the order which is passed by the circle officer dated 12/4/2022, which is annexed as, well, in this, should you have annexed as annexure? Mr. Parme, you have annexed this annexure as annexure
Annexure number 1, my lord.
1,
My lord.
13/33 as annexure 1. Annexure 1. In this context, the learned counsel for the petitioner also relied on the decision of Honorable Apex Court. Honorable Apex Court reported in AIR 2017, Supreme Court 1947. Black Pearl Hotels, Black Pearl PARL, Pearl Hotels Private Limited versus Messrs. Planet M Retail Limited. Next one. In this context, the learned counsel, Mr. M. Doji, appearing on behalf of the respond number one also submitted that the circle officer has no authority or judicial power to pass the order in a appeal, which is filed against a Kebang decision. And hence, it is submitted that the order which is passed by the circle officer is liable to be set aside, and he also agreed to the submission, made by the learned counsel for the petition. Next paragraph. Section 46(1). Section 46. Section 46(1) of this is the
Assam Frontier Regulation Act.
regulation.
Assam Frontier.
No, not Assam. It is not Assam. Regulation in forest. Okay. Act, which is the act under?
This is my lord Assam Frontier Administration Justice Regulation Act, Regulation 1945, my lord.
Assam?
Assam Frontier, my lord. Under bracket administration of start from page of 53, my lord. 53, my lord.
53.
3, my lord. 53, my lord.
Oh, acha. 53. Assam. The Assam Frontier Administration of Justice. Administration of Justice is in bracket.
Within bracket.
The Assam Frontier, bracket or Administration of Justice, bracket close, Regulation Act 1945. Speaks as under, read as under, this has to be quoted. Huh? (46)(1), he quote the 46(1). So from from plain reading of section 46(1), it is seen that the appeal can be filed before the assistant commissioner if the suits not in the suit not exceeding ₹500 on value, and otherwise it and it can be filed before the deputy commissioner if suit value exceeds ₹500. Thus, it is seen that there is no any there is no any provision of delegation of sub-delegation of judicial power or authority to decide in an appeal by the circle officer. So considering the submission made by the learned counsel for the both sides, and I want the opinion that the order dated dated 12/4/2022 was by the circle officer, the Kabadi circle. And hence, last line. recovery is illegal and arbitrary, and which has been passed without the proper authority, and hence I find that the same with the order passed by order dated so and so, pronounced by the learned circle officer on behalf of the Deputy Commissioner Recovery, Lower Siang District, Arunachal Pradesh, is liable to be set aside, and accordingly, the same stands quashed and set aside. Both the parties are at liberty to approach the forum. You want to file afresh, you have to file afresh otherwise. Or is there any submission?
Yes, but I will file. Liberty may be given to approach the
Liberty may
right.
be given to the both the parties to approach the appropriate forum with proper application.
Yes, ma'am.
Liberty, both the parties are at liberty to approach the appropriate forum with proper application declined against the order of against the Keba decision dated 27/5/2020. With the above observation, the present stand disposed of.
Yes.
Mayor Lordship. Item number 3, Lordship, this and for the petitioner has come up after or delay has been condoned by its honorable court. This is an RFA Lordship.
Delay is already.
On the raise has been condoned.
The day of Wakalatnama on behalf of sole respondent, no?
Lordship, I am for the petitioner. I am the
No,
petitioner.
you are for the petition.
Yes.
The Wakalatnama has most probably filed on behalf of the respondent.
Yes, Lordship.
The name of the other council is also reflected in the cause list.
Yes, Lordship.
Let the matter be listed for some other day, otherwise. they are
Lordship,
absent.
since they have filed an execution petition before the learned civil judge senior division, so this matter may be taken up on Lordship. Can this be fixed on 3 of August, Lordship?
Third of August.
Yes, sir.
Let the matter be listed on 3rd of August. For admission period.
Deeply written.
Yes, I will.
Yes.
Now, my lord, this is joint application, my lord, both by the accused and the victim, my lord. There is accused are 2 in number, my lord, or victim as well, my lord, 2 in number, my lord. Now, this is joint application, my lord. By 4 person, my lord. 2 are accused, 2 are a victim, my lord. Now, the is non-componable, my lord, section involved here is
57.
457, my lord.
457 is not.
Yeah. Now, maximum punishment, my lord, is 5 years, my lord. Now, where I am, my lord, praying, my lord, under 482, my lord, where my lord will evoke the jurisdiction in my favor, my lord. My lord will kindly note, my lord, the big accused, my lord, at that point of time, my lord, where 20 and 19 years, my lord. Now, the 2 accused is there, my lord. Petitioner number 1, my lord, was age about 20, my lord. Petitioner number 2 is also accused. He was 19 years, my lord. Now, my lord will kindly appreciate, my lord, during those.
19 years, 18 years, but all are 42 years, 41 years. 40.
Now, my lord, the incident is of 2000, my lord. 2000, my lord.
It took incident is of 2000.
2000, my lord.
2000.
My lord.
It's more than 20 years.
So that time, my lord, this is a long pending case, my lord. Additionally, my lord, taking into the incident, my lord, their young tender is, my lord. Not only this, my lord. In addition to this, my lord, present agreement, my lord, the issue, my lord, was solved by them, my lord. If my lord kindly turn to page number 32, my lord. 32, my lord. Okay, this is my lord, the withdrawal letter, my lord, by the victim, my lord, saying, marry this, my lord. Withdraw the case against such and such, section number 457, 323, 34 IPC. I have the honor to inform you that we have been locally compromised the case settled of both party on 2/10/2002. Therefore, I highly request you to kindly withdraw case against the above mentioned, which I was filed on month of August 2000. My lord, to kindly appreciate also, but this was well said 2000, my lord. Now, after so many decades, my lord, 2 decades, my lord, was you getting a person, my lord, that has been settled, my lord, way back in before 2 decades, my lord. My lord, I humbly believe, my lord, this is a pit case, my lord, where my lord will evoke for section 482, my lord.
So why they waited for 2 decades? To
No, my
give
lord,
us a
yes, my lord.
Yes, this is the application where it can be seen that a prayer was made before the extra assistant commissioner for the withdrawal of the case.
Yes, my lord.
But thereafter, after this petition. was
Thereafter, my lord,
2002. So after long 20 years, they were.
Charge sheet was also filed on 9, my lord, 2000, my lord. But then, my lord, trial, my lord,
Ago case was.
was the trial of this case, my lord, was at page number 65, my lord, transferred to my lord. Judicial magistrate, regular magistrate, judicial magistrate first class Narlogan on 9/9/2016, my lord. 9/9/16. And trial of my lord, 66, my lord, started on 19, my lord. Thereafter, my lord, due to COVID situation, my lord, this case, I think, was keep on hold, my lord. After 1920 order is also there, my lord. After 20, my lord, directly, my lord, 23, my lord. Now there's some this is misplacement or some COVID situation, my lord, this was taken. Now, other aspect, my lord, I will also indicate, my lord, my lord, the injury report, my lord, will kindly see it, my lord. Page number 58, my lord, of the victim, my lord. 58, my lord.
Well, yes, obviously, injury is most probably almost simple in nature.
Simple, my lord. And then
Because the section which is quoted, it seems that the 323 is registered. So obviously, injury was simple, but rest upon it was 457.
Right.
That is the main issue.
My humble submission, my lord, is looking into the tender incident when happened, my lord, that at a young blood, my lord, sometime, my lord, happened, my lord. I'm not going into the other aspect of the, only I'm trying to indicate where my lord will invoke the 482 in my favor, my lord. Only that aspect only I'm trying to indicate, my lord. One, my lord, the incident happened when the person accused, my lord, where your tender is, my lord. Normally, humanly that is possible, my lord. That some due to hot blood, my lord. That's
Hot blood.
sometime, my lord. Now, my lord, within, my lord, Apollo, within 2 years of his, my lord, that was compromised, my lord, and withdrawal letter is also there, my lord. Now, presently, my lord, I am on this agreement that my lord, my lord, that I have annexed at page number 70, my lord, annexation number 6, my lord. This is the ultimate, my lord, mutual settlement, my lord.
This is the agreement.
Settlement, my lord. So, as the case, my lord, is very in initial stage, my lord. Now, only evidence, my lord, next step, my lord, is that not a single, my lord, prosecution witness, my lord, has been recorded in this case, my lord. So, taking into those aspects, my lord, kindly, my lord. I believe, my lord, I would not need to rely, my lord, citation, my lord, 482, my lord. Like, my lord, no, these all cases, my lord. I do believe, my this is Gyan Singh, my lord. Narendra Singh, my lord, no, my lord. Only those aspects. But I need to submit this, my lord.
Submit. If you want.
Yeah, Lordship, actually here, three sections are there, Lordship, 457 and 323 and 34 IPC. Lordship, 457, actually, my lord, the house trespass, as per the FIR, Lordship, it appears that the house trespass is on this other party, Lordship, the complainant house. It's not a public place, Lordship, because in the section 457, there's two columns, Lordship. One is, Lordship, para one, which is cognizable and non-bailable, which is imprisonment for 5 years. And another is para two, which is non-bailable and travel by first class at prison for 14 years and above, Lordship, which is for like, Lordship, temple and the temple like on where the worship and the, Lordship, where that everyone is not allowed. It should be very protected places. So that kind of places, how trespass there, then the punishment is longer and very severe in nature. But I think this is, Lordship, is not that severe. It is not a society as a enlarged a society for the Lordship, and it's only personal Lordship. This whatever it is done. So Lordship, private in nature, Lordship, and Lordship. And this 323 Lordship is also, I feel like, it's simple in nature. It's not grievous. And moreover, Lordship, as we can see, all the record is pending for 20 years, more than 20 years. So it can be bit fair case for the passing. And Lordship, like Lakshmi Nayan also, Madhya Pradesh versus state of Madhya Pradesh and Lakshmi Nayan, where the Lordship, which is not against the society, which is not heinous crime, it can be quashed, Lordship. And it's a bit class.
I'm really thankful, my lord, for peer submission on the part of PP, my lord. Now, my lord, kindly give.
Hot blood, they were hot-blooded at that
My
time because of their age.
My lord,
That's why.
yes, my lord, one thing, my lord, I will indicate, my lord, here for my lord, kindly note 457 two part, my lord.
Yes,
One, my lord.
That's what she was
My lord.
submitting.
Second part will be not attack against me, my lord.
It is of 14 years and other part is.
High level,
Okay, your question is disposed of, will be allowed.
high level.
Item number 4, I'll pass the order. Item number 4. This is disposed of. Yes,
Yes.
5, yes.
My lord, the accused person, last occasion, this honorable court has given me some advice. If really that accused person is such a sickness, he may be placed doctor and medical prescription. So there we have taken the last of my lord. It was referred from the Arkansas hospital due to psychiatric problem, and there's some abdomen problem. So it was referred to Dibrugarh or this Guwahati or somewhere. And it is already been 2-3 days. Again, his health condition not good. So we have taken him the Nahalawan trims for physically checkup. So I would like to show that this medical prescription this before this honorable court.
So where the order was passed, the order speaks nothing about the, it was verbally, you were advised by this court.
Yes.
The order doesn't say so. That's what I'm.
So his health condition is not good. So this was the medical prescription has made. This is on. This is on. 2107. Again, his health problem is not good. So we have taken him at Nahalawan Trims Hospital, where is the available doctor. So the doctor has a prescription. This is the post-rheumatic stress disorder. So this is stage accused person, if arrest, that will be more his health condition and will be deteriorated, and there is a highly chances of the suicide or uncontrolled physical reaction, a mental issue of coping, severe anxiety and nightmare, changes of mood, and fail to flashback even and negative thoughts. So this is the medical ground I place before this honorable court. And one more, I would like to make clear that police has not properly done as per procedure. So the section, that's a section which against me, section 3 of Prevention Act, Prevention of Damage to Public Property Act 1984. My lord, this is a central act. This is particular for central act, central property by damage. So this section is attracted to me. But as for today, what happened? We have on codified this law that not against this law, but as a for the common people for Arunachal Pradesh, we have made a different court which has passed in assembly. So this is Arunachal Court, Arunachal Court, Volume 8. Yes. Arunachal Pradesh, Volume 8. Volume 8. This is particularly made for Arunachal. Those who are who is complaining in this very case, EAC of Upper Subansiri District Administration. He belongs to Upper Subansiri Daporijo District Administration, and property which allegation made against what property is from the Arunachal state only. So this act is not attract to the Prevention of Public Property Act 1984. That is a central act. So even the central act also, there is a section 5. Central Act, section 5 also, for detention procedure how to grant a bail. So my lord, kindly see the section 5. Special provision regarding bail. So no person accused or convicted of offense punishable under section 3 or section 4 shall, if any custody, be released on bail or on his own bond, unless the prosecution has been given any opportunity to oppose the application for such release. This is the Central Act. My lord, I would like to go this Arunachal the court. That is kindly see the page number. Arunachal court. This is enacted. This is passed from assembly. Arunachal Pradesh. Kindly see the section 4, the page number 162. Page number 4, section 4. Here said that, my lord, please, if the state officer is the opinion that any person is unauthorized occupation or any public premises that should be evicted, the state officer shall issue the matter thereafter, provided a notice in writing calling upon all the person concerned to show cause why or of eviction should not be made. This is the procedure. They have not followed the as per procedure. Even they have given they have codified on state law, but they do not follow as per. They have charges again with section 3. This is not at all this is illegal if I'm not wrong. So my lord, this is at all not improper in the Arunachal police as which they have against me section 3. So while see that this is, I would like to submit only these few words. So accused person fit to be released by the protect given a protect full absolute bail. If
Yes.
Yeah. Right now, I don't have the. But as far as statute of both central and state government, almost same. Only in place of central government, there was inserted state government. It is almost same. So section 3 is regarding appointment of the state officers. And section 3, section 3 is followed by automatically followed by section 4 and 5. What state officer has power in such case of enforcement or such case of this is a government land, a SPT type government land, whereby government has already allotted to one union. That's I have put paper flag on the CD.
Yes. Yeah, flag mark.
Yes, flag mark. Already allotted to cluster federation, Dapo Ane Cluster Federation. And this applicant is now constructing in RCC structure in that place. Whereas it is already recognized that this is a government land. Allotment is there at last phase of the CD.
Order.
Yes, allotment order. To the to any cluster level federations. And you know, prior to registration of FIR, notice was already served. Prior to registration of FIR. FIR is lodged by the DRDA, officer, government officer, district resource development agency. And that plot of land belongs to that department. So they have now evading. Only they have to appear after receiving of notice. Whether arrest has to be made or not, that is another question. They have, he was served only so-called notice. How it becomes yours? If it becomes yours, then prove. Then that is the question. But they're evading, making excuse. Last time, last occasions, this your lordship, this honorable court observed that they have hypertension, but they were not admitted at the hospital. To ascertain the thing, that's why matter was deported for today. Soon as seriousness of illness to be ascertained, but they only now annex the copy of this depression and something like that. Depression for what? Because of he is apprehending arrest. And this is a big question. Earlier he was a hypertension. But law cannot, depression cannot be interference for arresting the person. Whether certificate is issued by, this is only like a prescription that I have a problem of depression, but it was not certified by the doctor that he is likely to commit suicide
or likely to commit harm himself or other. So this is a serious case because he encroached the government land, allotted government land to others, and constructed a structure. Here, this is for anticipatory bail only, not for regular bail. So, notice has, I suppose notice has been received by him, already served. He appeared before concerned IO, and photograph is also there, how he dismantled the government quarter. Just appear before the IO, and so course, why he constructed the house, give the IO region, how land becomes to him. So at this stage, there are only 3 witnesses were examined. One, this former secretary of this union. Second, present secretary of the union. Third one is complainant himself was examined. So IO went to the spot for spot verification, photograph taken. There's ample evidence, sufficient evidence, prima facie case is made out. And evading is the most something inclined toward his guilty involvement. So at this stage, interim may not be considered. CD may be called for. CD was received, but rather my habab prayer will be, this application will be rejected at this stage.
So, my lord, my friend, he's a confusion. That's why I brought at this original court. He said that I've received the so-called notice. If I receive so-called notice, definitely I may be given liberty to submit as to why. Whether I have not given any the so-called notice. Show me the so-called notice if you have available. You don't have any so-called notice now. That is the allegation of the police. And section this the prevention central this is central act. That there is said different. In Arunachal court said different. They have not followed as per even my last submission also. Previous submission also I said that they should follow as per rule. No one can just simply submitting report is honorable court is not do. That they should go the procedure as per procedure. What procedure said? I have not destroyed if I destroy the property, any government property, it is not attractive to central government. This is I have not if they have made allegation in the charges me the Prevention of Damage of Public Property Act of 1984. And what is the value of this Arunachal court?
I have an objection.
Then let me complete. What is the value of the Arunachal legislature to enact this law?
This is a disputed fact.
Let me.
And this court has no jurisdiction.
And you cannot, my friend, you cannot challenge the doctor prescription. Let us only that is only 2107. Let us the sickness can be happen anything. You cannot predict. This is not as a immobile property that it can be kept in some. This is sickness. Anything can happen. No one can grant. That's why I am local people of Arunachal Pradesh, local people of Daporido. I'm ready to pace. I'm ready to pace a trial. I'm ready to cooperate the eye of the case.
If he has right title about the matter, only
my lord,
it's a matter question of 2 minutes, 3 minutes. It's only a question of if he has a good title about the matter land, then it is a question of only 2-3 minutes just to interrogate how you
that's why I'm ready to cooperate.
Appear.
I'll go my district, I'll cooperate. And even
Your good name is not reflected.
T Dukom.
Huh?
T Dukom.
Administrative, also had Mr.
Gita though.
Additional people. Appearance of the status. It's an application under section 12. It is submitted by the Mayor and Council for the petition that the present case is the FI is lost and registered under section 3 of
PDP, PDPP.
PDP regulation. It is there. No, it's logging the FI and searching for. FI is a page. FI is a page
11 to 15.
11.
11 to 15. Hard copy is at 12.
Start under section 3, no?
Yes.
Under section 3 of P 3 of PDPP Act
Yes.
1984. But the property which is against which the said case has been registered belongs to the state government of Arunachal Pradesh, and hence the petition, the FI ought to have been registered. Ought to have been registered under section, your section is 3.
Yes.
of- Under section 3 of the Arunachal Pradesh public premises. Arunachal Pradesh public premises, regular
Section.
section of unauthorized occupants, regular eviction of unauthorized occupants Act 2003.
Same.
Further, it is submitted that the accused petitioner is ready to cooperate the IO in further investigation of this case. However, where you have written your apprehension of arrest?
Hmm.
Regarding your apprehension of arrest? Yeah, not sure. Again, it is further submitted that the present FI has been lost with an allegation that the present petitioner, accused petitioner has illegally encroached upon the go down number 1 and type 2 of and type 2 quarter of DRDA near DPO office. Goporijo.
This is
Do
only,
you know, innocence or what is?
this is not only encouragement, but also includes destruction of public property.
Destructing the, after destroying the public property, that is the quarters which were there in the said premises. However, the present accused appellant is not at all, you are involved in this case, no?
No, no, no. That's why I'm ready to paste the paste.
Involved in the alleged offense and false allegation is brought against him, wherein he is, brought against him and lost the FIR against the present accused petitioner. However, he is ready to cooperate with the IO if he is granted with the pre-arrest bail. Further, it is submitted that the accused is suffering from some post-traumatic stress disorder. And he has already consulted with a medical practitioner on 21/7/2023, and he is under severe depression. And there may be any suicidal attempts out of his depression. And with the enhanced with the apprehension of arrest, the present petition is filed by the accused petitioner seeking pre-arrest bail. CD is already received. There is the same. And a learned additional PP is submitted in this regard that the registration of a case under section 3 of the Central Act or the Arunachal Pradesh Act will come later, but the subject matter of the main allegation brought against the present accused petitioner is that he is doing mischief by constructing by erecting some
RCC structure.
by erecting some RCC constructions over the public property, which is allotted in the name of DRDA. It is allotted for DRDA,
No, allotted by the DRDA.
allotted by DRDA.
Yes. This,
Allotted by DRDA.
Dapo ane cluster level federation upper
Allotted
Sulawesi
by DRDA to Tapo NA
cluster level federation
Federation,
upper
a
Sulawesi.
self-help group. However, if the, the notice has already been issued to the present accused petitioner, asking to show cause or reply as to whether he possesses any right over the said land, but the accused petitioner is avoiding arrest, and did not appear before the eye and came and filed the present petition seeking pre-arrest bail. Further, it is stated that in the earlier occasion, the petitioner took the plea that he is a patient of hypertension. But today, the medical reports speaks in other way, and it is as per the medical prescription of the doctor, he is suffering from traumatic stress disorder. The further it is submitted that the notice was issued only to record his statement as to whether he possesses any right over the said property, but the accused petitioner is avoiding the notice and did not comply with the provision of the said act. In this regard, the learned counsel for the petitioner submitted that he never received any notice from the authority concerned to appear, asking him to appear before the IO or to record his statement in connection with this case. However, he is ready to cooperate the IO in the investigation of this case if he is protected under some interim protection. If he is granted with the privilege of pre-arrest. Considering the entire sufficient medical learned counsel for both sides, and also considering the metricity case record, etc. Vis-a-vis the health condition of the accused petitioner. I'm of the opinion that this is a big case where the interim pre-arrest bail can be granted to the accused petitioner with a direction to appear before the investigating officer and to cooperate in further investigation of this case. And till recording of the statement, the case diary be returned back with a direction to furnish the press to up-to-date diary along with the statement of the present accused petitioner if recorded by the IO. Let the matter be accordingly listed. No, not absolutely, but 20,000 with 1 security with some, there will be some conditions within 7 days he has to appear. So you have to appear before the IO within 7 days
Yes.
from the date of order, and your statement after recording of your statement, we'll see for final disposal of this matter. Till then, it is your interim protection, and matter will be listed after date of admission after 4 years.
My lord, here as per Dr. Priskam, 15 days maybe under treatment. That is.
You can go, not 15 days, within 7 days, you can appear. He can erect the construction over the government property, and now he is suffering from such a. Huh? 3rd of August, no, absurd. Because if they are in interim protection, so let it be fixed on. The 16th of August. 16th of August. And within 7 days, okay, then if he has in prescription of the doctor, then make it on 10 days, within 10 days of the date of birth.
Then your one more condition may be added. Section 3 is followed by section 4, 5, section 4 and 5. 5 is for eviction. If section 3 and 4 is not complied with, notice is issued, and after receiving, not appearing, then no more further notice is required. It will go directly eviction.
So I don't want to pass by record any such observation here at this stage, because it is 3, 4, 5 will follow definitely. So let him appear first. Let this statement be recorded, and if it reveals that he has no documents, etc. for to construct the OVD in a construction. Otherwise, he is saying that he is not at all involved, neither he is constructed so and so. So that means he has no any documents or papers in his name to claim that property. So in that case, if that will be the position, that
Only simple sentence, Your Lordship. If order is not, this honorable court order is not complied with, then authority may act in accordance with law.
that will definitely come on when the
No, it may be reflected if otherwise he will make excuse and excuse.
My lord, let the PP2 go through entire this court volume 8. He's confusing this.
No, it's clear law that 3 is not followed with, 4 is not complied with. Then no more further notice is required, and so that in accordance with law, authority may act.
Let us see, let him appear, and if not appear on 16th August itself, this petition will be rejected, and the will be at liberty to even to arrest the accused. That will be there, obviously.
Much obliged.
CDP return. CD return.
Your Honor, I may be allowed to withdraw this bail application with liberty to file before special judge UPM.
You want to withdraw this one?
Yes, Your Honor.
Liberty, you are at liberty. Definitely you will be at liberty.
However, it may be mentioned in the order sheet.
Okay. Hard Mr. You are Mr.
A Bodo.
A Boro, the learned counsel for the petitioner. And also hard Mr. T. Kalu, the learned petition to be appearing in the court state respondent. It is submitted by the learned counsel for the petitioner that due to some technical reason he wants to withdraw the same. With liberty to file a fresh. Withdraw the same. Mr. Hard. Accordingly, the prayer for withdrawal is hereby allowed. However, the petitioner will be working to file any other bail application in appropriate or proper forum. I won't say special judge, you can file it, you are at liberty to file any other proper forum if it is your liberty. So
Okay.
matter will be disposed of on future.
Obliged.
Number 8.
Consent? Appellant remain absent on call. List the matter accordingly after 3 weeks.
Yeah,
This is a petition.
this is the transfer. Lordship, in fact, I have received the affidavit in opposition filed by the respondent. Now we have,
Respondent is already appealed.
Lordship, I think they have filed their Bakla Tama, Lordship.
And list of documents you have filed. Who filed this one?
I'm correspondent.
No, list of transfer documents. You have filed this one
Yeah.
for the respondent side.
Lordship, may kindly come to page 6 of their affidavit in opposition.
Have you received the?
Lordship, I have received. So I am making a submission of their affidavit in opposition, Lordship. We both have agreed that in my petition, I have prayed for transferring the matter to Teju. Now I have seen their,
Presently, where it is pending?
Lordship, it is pending here, Lordship,
Here at UPI.
in UPI, Lordship, JMFC court. Now we have come to a consensus saying that this matter can be transferred to Pasighar, Lordship, in place of Teju.
And in that case, will it be convenient for you to?
Both
appear it?
for convenient for both, Lordship,
Convenient for both.
both. We have prayed for transferring to Teju since, in fact, the respondent was posted there at that point of time. Now I have seen the records. Now recently he has been transferred to Pasighar. And both of us are permanent resident of that East Siang district, only say the district where the respondent has sought for transferring, has consented for transferring the matter. So we both has consented. This matter may be transferred to CGM Pasighar. Let necessary order may be passed.
So you don't have any objection? If
Earlier-
transfers to-
Earlier Teju, I make objection Teju, but Pasighar presently I have posted to Pasighar, so I don't have any objection.
You are also presently posted at Pachigat.
Yeah,
And you are also.
No, Lordship. I am posted at Anini, Lordship. Anini.
But
I am
what-
working as a stressor in JMFC core. Anini, it's quite far.
Anini.
Anini, 150 kilometers from Itanagar. Lordship. It's take 2 days coming, going it takes 4 days. So why I have filed this transfer petition for transferring the matter to Teju. So Teju it takes 1 day, and Pasighar also will take 1 day. I agree that even if it is transferred to Pasighar, I don't have any objection.
And you are presently posted at Pachigat.
yes,
He is posted.
So matter may be transferred from UBA to Pachigat.
yeah, no objection.
No objection.
Yes.
So it will be transferred to CGM Pachigat.
Pasighar. Since there is no JMFC, CGM and session court is there. So CGM is the appropriate court for domestic violence case.
Okay, accordingly, order will be passed.
Lordship.
It will be discussed.
Lordship. Much of.
Without the vote, the more I have noted down, well, it is here, this is distinct of the. If you put two cast this dictation, who took this of this book? You. So,
ये क्या बोला रहा हूँ क्या बोलता है हाँ पेपर में है दे देगा